I'm Dana Brooks of Fasig Brooks, and I'm joined here today with Jimmy Fasig, my law partner, and we want to talk about workers' comp injuries and really just any injury where you're hurt on the job. And a lot of people think that if you're hurt on the job, then you can't sue your employer and you're going to have to pursue a workers' comp injury, and that's your only avenue of recovery. Sometimes that may be true, but it's worth a call to an attorney to find out, because there could be other avenues of recovery, and we'll talk about that in just a minute. But for the most part, when you're hurt at the office or hurt at work, and even if it's your own fault, maybe you're not paying attention, workers' compensation is usually your exclusive remedy, meaning you have to pursue that. You don't get the option of just suing your employer in case you got hurt because your employer did something wrong or was negligent in some way. But that's just as to the relationship between the employee and an employer. But Jimmy, talk about some other avenues of recovery when somebody does get hurt on the job.
Okay, so what you're talking about, Dana, is called third-party liability. Third-party liability is the liability of a third party who is not your employer and not a co-employee, because the exclusive remedy provision of the workers' compensation statute says that if you get hurt by your employer or a co-worker, you have no remedy outside of workers' compensation benefits. However, if you get hurt by somebody who is not your employer or a co-employee, then you can sue the person who caused the incident because they are not protected under the exclusive remedy provision.
Give an example of that.
Okay, example. So let's say you work at a grocery store and you end up slipping and falling at your own grocery store. Well, you cannot sue, let's say you work at Publix, you can't sue Publix. You cannot sue your co-employee who may have spilled the water on the floor and failed to mop it. But if, let's say, for example, the spill on the floor that caused you to slip was done by a third-party contractor that is hired by Publix to come in and clean the floors, that is third-party liability. If it's their fault, then you can sue them.
Well, I have another example. Someone I know fell downstairs at their workplace. You think they're just not paying attention to where they're going, or maybe the employer wasn't being, cautious enough and making sure it was a safe place. It turned out that the people who installed, the company that installed those stairs didn't install them to code, and one of them was at the wrong height, and so the person wouldn't have anticipated that descending the stairs, and that's what actually caused the stumbling and the fall down the rest of the stairs. So that's where, that contractor that installed those stairs, has some liability. It could be manufacturing. Maybe they were installed completely fine, but they were manufactured poorly or not to code or standards. So it's always worth a call to an attorney to run the facts by them and find out. And you know that you could always call us anytime. Absolutely.
There are a couple other things I want to add about that, about the workers' compensation statute. Other exceptions to the exclusive remedy provision are if it's an employer or a co-employee is guilty of gross negligence, which is negligence that is really egregious. It rises to the level of an intentional tort, then that is an exception to the exclusive remedy provision. So
not just carelessness, it's something that is just so careless as to the point of just being, absolutely unconcerned with the outcome, knowing it could be horrible.
Yes, and then there's another doctrine called the unrelated works doctrine, which says that if a co-employee injures you, that co-employee works at a part of your company that is completely unrelated to the work you do, there may be a potential liability.
And you can see that whenever there are huge, multinational, international employers, that they shouldn't get the protection of something that is not intended to protect them in that situation. So,
yes. The other thing that I think is important to remember about workers' comp is that you can, a lot of times, even though you are getting workers' compensation benefits, you still can get compensation for your pain, suffering, inconvenience, lost capacity for the enjoyment of life from the third party. Right. What happens is your workers' compensation carrier will also get reimbursement from the third party for part of whatever they paid.
So you're not double dipping, and that just sounds fair. The lawyer would know that and tell you how that is all negotiated and put your interest in front. So always feel like you can call us anytime. We're at 222-3232 or FasigBrooks.com. Thanks for listening.
Thank you.